That's what they're going to argue every time.
Yep.
And I am afraid it's going to work. And Leslie and I are dealing with this right now in a county that will not be named, because I think that we might get thrown in jail the next time we go anyway. So the last thing I want is to splash it out on the headlines at this point. We're the Armed Attorneys. Today we were talking about the new constitutional amendment that just passed here in Texas.
Yep.
Stick around. We're going to talk about what has happened. We're going to talk about why the horrendous crime rate we've been seeing all over the state and the country is now coming back to really hurt self-defenders. And we're going to tell you about what you're going to need to know if you're found in the situation. But before we get started, show your support for the Second Amendment by hitting the like button. And Leslie.
Yeah,
we're back. We're just talking about the law. It's self-defense adjacent this time.
You know, I think this is something that people don't think affect people who act in self-defense. And unfortunately, when laws like this are passed, which probably protect a lot of people, they don't think about people acting in self-defense.
No, and I guarantee, because this constitutional amendment we're talking about, it was Prop 3 here in Texas. And it was couched in such a way that I guarantee that basically like 98% of self-defenders and people who own guns voted yes.
Probably so.
Because it's like, we have this proposition that's like, hey, we need to keep the worst of the worst, ultra violent offenders. We need a way to deny them bail, because in Texas, I mean, when could you deny bail before this?
Only if it was capital murder or if it was a motion to revoke probation.
So we have, I mean, very few instances. Now, practically speaking, you could set a really, really high bail, and that's basically a denial of bail, which is why this was totally unnecessary. But practically speaking, there were very few instances. And then this proposition came in and said, well, hold on. We need judges to be able to deny murderers,
rapists, sex offenders.
Yeah. You know, Samir, bleep whatever we can't say on YouTube. By the way, please sign up for our newsletter. We are going to start giving you uncensored content in the newsletter. And by that, I mean, you know, nothing totally outrageous, but just things that we can't actually say or talk about adequately without getting demonetized on YouTube. Go to armedattorneys.com, sign up for our newsletter. Okay. Yes. So the worst of the worst, right? In jail. So Leslie, what does the law do now?
So basically what it says now is that a judge can deny bond for a person if they've been charged with murder, aggravated assault, if there's an injury and or a weapon used, sexual related offenses, and then, you know, robbery, armed robbery. There's a litany of more. But the ones that really are going to affect people using self-defense are the murder and the aggravated assault. That's a big one. I would say probably 85% of my clients who get charged with something as a result of a self-defense incident are charged with aggravated assault with a deadly weapon.
Right. Because anytime you use a gun in self-defense, whether you shoot it or not, as long as the person doesn't die, you're getting charged with aggravated assault deadly weapon. So that is the majority of our dockets as self-defense lawyers. And now we're fighting you're already fighting an uphill battle when you're charged with a crime. And now your lawyers are fighting another battle, which is that the government is always going to ask that you be placed on a no bond. And now we have to fight that too. And the judges, I mean, if the judges were smart to begin with, we wouldn't have this Proposition 3, because they would be setting the bond super, super high on the bad people. Because we have this amendment because the bad people were getting released on PR bonds and very low bonds, hurting people again. And then you have those big splashy news headlines about guy out on bond for murder, just ag assaulted someone else, or just killed somebody else, or just, you know, committed something else that's very heinous. And so here we are, the judges aren't that smart to begin with. And so when we go and we say, hey, this guy killed someone, yes, but he did it in self-defense, the judges are going to say, well, it's a murder, no bond.
And, you know, what they're concerned about, obviously, is all the judges in Texas here they're voted in, they're elected, they're elected officials. So while the judicial system should run and make sure that justice is done, and I think, you know, there's some of that, but a lot of it has to do with elections and getting reelected. So, you know, these judges are going to be the ones who are scared to not no bond someone. And then let's say that person goes out, like Emily was saying, you know, then they commit another offense, what have you. So the problem we have is that, you know, our clients always think, oh, well, they're going to hear it with self-defense. The judge doesn't care because they just heard, you know, 7 cases of whatever, and they're just no bond, no bond, no bond, no bond. Now, don't get me wrong. There are going to be the few really good judges who are left out there who are going to say, okay, well, let's hear the facts. And they're going to go through and they're going to look at every single one. But the problem you have is getting that judge who this is going to be their new thing. They have a way to no bond people. Heck yeah. They're going to no bond everyone they can.
Yep. They get their primary opponent, challenger. They're going to be like, well, look at me. Look at the percentage of my docket I put on a no bond. Never, ever. No one is ever going to stand up for the self-defenders who didn't deserve it. I mean, the defense lawyers will, but it's not going to come out in the news. So, there is, I guess, a safety in this law, but it's not going to work.
Right.
So that safety is that the state has to prove that your bail is insufficient to ensure your appearance in court. Self-defenders, that's never going to happen. Y'all are very responsible.
Absolutely. Never miss a court date.
Never miss a court date. Nobody's worried about that.
Right.
Or they have to prove that you being out bond endangers the safety of the victim. That's not going to apply to you guys. The catch-all. Or that it is dangerous to the community. It doesn't keep the community safe for you to go out.
And that's what we're
bond.
going to have the problem with.
That's what they're going to argue every time.
Yep.
And I am afraid it's going to work. And Leslie and I are dealing with this right now in a county that will not be named because I think that we might get thrown in jail the next time we go anyway. So the last thing I want is to splash it out on the headlines at this point. But I think it's worth talking about because Leslie and I just engaged in like the legal equivalent of
war,
taking our earrings off basically in the courtroom. Like we're like, all right, let's go. So do you want to talk about that?
Yeah. Right. Yeah. I mean, this is a situation where, our client is on bond and has been on bond for years now, has never missed a court appearance. And again, that's never the problem with people who are acting in self-defense because they're, lawfully abiding citizens. Our client was found in possession of a firearm. A bond condition says he can't have a firearm. And now he's facing going back to jail and having to sit there until his court date, basically.
And the government is arguing he's a danger to the community. This affects the safety of the community. To which I say, that man has never hurt anyone who wasn't pointing a stolen Desert Eagle in his face. But okay. But that's what they're arguing. And you know what? It's going to work, which is why Leslie and I just like went all out to war and are trying to recuse the judge and filing motions to seize cell phones of all the government actors involved. And if we disappear, it's because the government in this county disappeared us. It's not good. But it is, you are fighting this uphill battle and the hill just got even a hell of a lot steeper.
Because I can promise you, in our specific case, this doesn't go into effect until January of this coming year. Had this been in effect, we wouldn't even really have much to argue because the state would just say, "Oh, he's a threat to the community," and he's not. There's no proof that he's a threat to community. And the other problem we have with our self-defenders, it's not a problem, but what the state's going to say is a problem, is that most of our people who act in self-defense are firearms collectors, right? Yep. So the state's going to bring up, well, judge, they have 10, 15, 20, 30 guns at home, which
the arsenal,
yes. Which again, normally one of your bond conditions, you can't be in possession of firearms. So presumably they're going to disarm you anyways, but they're still going to make that argument. Judge, not only did they kill someone, but they had this arsenal at home. Like they were ready. No, they're collectors. But again, the state makes it sound bad. And this made it much easier for them to do. The other scary thing about this is that there's no live testimony required. So typically in a bond hearing, you don't have to have live testimony, I suppose, but typically how it works now is that there is live testimony. I mean, you have a chance to put on testimony and to show that your client isn't, a threat to community, what have you. This doesn't require this. So basically now the state can just put something in front of the judge and say, here, judge, read this. And that's that. So that's scary.
It's going to be rubber stamped. And then you are going to, as a self-defender, be sitting in jail until your court date. Yeah. And I cannot tell you how many people, especially good people like you, sit in jail a couple weeks and then they're like, oh my gosh, I have to plea. Can I plead to anything that doesn't put me in prison? Convict me of, what was that case I had way out in the sticks that time? Abuse of a corpse. Convict me of abuse of a corpse, like just as long as I don't have to go to prison, because it's you've lived out in the free world your whole life, and all of a sudden you're incarcerated, and you do pretty much anything to get out, including sacrificing your reputation for something that you don't deserve to be convicted of. So, I mean, it really is. This is a huge travesty for self-defenders going forward here in the state of Texas, all because we were letting out super bad guys on bonds. And again, like, I don't blame people who voted for this, because that's what they're trying to control.
Right. And I mean, my mom, for example, was telling me how great this was at this pass, because now we're not going to hear on the 6 o'clock news that the guy who was out for murder just murdered someone else. And I was like, Mom, this is awful. And I had to explain it to her. And her response was, oh, well, yeah, I hadn't thought about that. Well, no, because no one thinks about the person who is acting lawfully and defending themselves, because I think most people believe that if you're acting lawfully and defending yourself, you don't get arrested.
Yeah.
And that's not true.
Yeah.
It's just not true. People get arrested every single day. Self-defense is a defense you get to use in a courtroom. So it's not a bar to prosecution, and it's not a bar to being arrested. And I say that sentence probably 15 times a day. And people are always like, well, wait, but it was self-defense. They can't arrest me. They can.
Sure can.
You just get to say self-defense in a courtroom.
You know what's really annoying about this one? So at the legislature this year, there was a bill that included this, and it also included some provisions for, like, basically ICE detainers. And I actually went and testified against it. And it was the one where I was on the same side as the ACLU lawyer, which is weird. He was very nice, very light in his loafers, but very nice. And like, I thought, okay, we defeated it. We defeated it. We did what we were supposed to do.
And here it is.
And here it is, back in my face. But, I mean, all I can say is this is one of the reasons why you have to stay out of the self-defense situation in the first place. So sign up for our newsletter, because I tell you what we're going to do. We are going to start taking real self-defense cases, breaking them down, talking about the law. Get involved in that thing, because that's part of how you avoid the situation and make sure that you are not going to end up arrested in these cases to begin with, right?
Yeah. And also, I mean, we, can tell you about the upcoming bills and what effects they could or could not have for self-defenders and Second Amendment rights and that sort of thing.
So we hope you enjoyed this episode. If you did, consider subscribing, hitting the like button, and help us fight the anti-2A algorithm by sharing this video.
And if you have questions or comments or anything like that, be sure to comment down in the section. If you have questions, put the word question and then type your question out. It's a little easier for us to find the questions, but we'd love to hear what you think about this new amendment. And
until next time, we're the Armed Attorneys.
Yeah.